Welcome to Podcast Bites by India Law LLP. In today's case, the Associate Builders versus Delhi Development Authority, given by the Supreme Court on 25th November 2014. It marks the definitive judgment on the limits of judicial interference in arbitral award. The citation of the case is 2015 3 SCC 49. In May 1992, the Associate Builders won a DDA contract to build 168 middle income group or MIG houses and 56 lower income group or LIG houses in Trilokpuri, New Delhi, whose contract value was rupees 87.66 lakhs and need to be completed within the 9 months. But interestingly, instead of 9 months, the project ran over 34 months, where only 166 middle income group and 36 lower income group houses were able to build. And also the total work done has only amounted to rupees 62.84 lakhs. The contractor blamed DDA and filed 15 claims before the Delhi High Court. And as per the Section 11, the court appointed an arbitrator. The key claims were given as the claim number 9, which talks about the higher charges for centering or shuttering, delay in DDA's electrical conduct work. Claim number 10, it includes the higher charges for virtual work stoppage, that is, which started from July 1993 to February 1994. Claim number 11, damages for tools, plant, scaffolding during prolongation. Claim number 15, establishment expenses, which include salaries, site officers, and etc. for 25 extra months. Claim number 12 and 13 talks about the damages of interest, which given as to be 20% and 35% for steep rise in material labor cost. In May 2005, the arbitrator passes an award and found that the entire 25-month delay is attributable to DDA delays in structural drawings, including electrical conducts, cement, steel, door shutters, even the color scheme also. Even DDA's own counsel considered this fact before the division bench. Award 23.39 lakhs out of 37.28 lakhs claimed. The single judge upheld the award, but they also set aside the claims 9, 10, 11 and 15 and scaled down the amount of claim from 7.5 lakhs to 5.57 lakhs, and the dissenting party went to an appeal to the Supreme Court. Justice Lowenthal Policy Nariman and Justice Ranjan Gogoi take up this matter and lays down the framework with the clarity. They stated out that the Section 34 talks about the grounds to set aside an award, which includes procedural incapacity, invalid arbitration agreement, improper or insufficient notice, matters beyond the scope, that is the ultra vire, or if the matter conflicting with any public policy of India. Section 5 bars any judicial intervention. Public policy, for the first time discussed in this case, ONGC versus Saw Pipes Limited in 2003. In this, there are the 4 heads given and define the what is the public policy. That is, the public policy contrary to the fundamental policy of Indian law or any Indian law. Second, contrary to the interest of the India. Third, against the justice or morality. And fourth, patent illegality. On fundamental policy, the arbitrator must act with the judicial approach, follow principle of natural justice, and not reach perverse or any irrational conclusion, that is, no evidence or ignored vital evidence or irrelevant material considered. On justice, it means an award that shocks the conscience of whole. That, for example, if there is a claim of only 30 lakh, then the award cannot exceed that claim. The award cannot be go beyond 30 lakh. It should be must 30 lakh only. That is what the conscience of justice. It does not mean the court substituting its own view of fairness. And this is what the principle of ultra voice talks about. That is, the court must not exceed its power or cannot go beyond the scope of the power given under the statutes or any law. The core principle is that a court does not sit in an appeal over the award of an arbitrary tribunal by reassessing or reappreciating the evidences. The arbitrator is the sole judge of the quantity and quality of evidences. The Supreme Court identified 5 errors. The first error, claim number 9, claim number 10, and claim number 11. The division bench said no evidence. Here, the word no evidence of higher charges. The contract required a class 1 contractor. Class 1 contractor simply means the net worth is more than 10 crores. But the evidence was placed before the arbitrator and thereafter was also accepted. The division bench was simply re-examined the evidences without power not to do so. Second thing, establishment expenses. Claim number 15. The division bench wrongly held that expenses related to Mayur Vihar, not Trilokpuri. They ignored the DDA's on completion certificate confirming the site, which was the Mayur Vihar phase 2 and which is also the part of the Trilokpuri Trans Yamuna area. Third, the applicability of Hudson's formula. The division's bench said it was mechanically applied. Supreme Court clearly stated in the case McDermott International versus Byrne Standard case of 2006, where they choose between the Hudson, Emden or Eckley formulae, which is squarely the arbitrator's domain, and no one can other decide. The courts can't second guess on it. Fourth, the formula base. Division bench said the formula should use actual work completed, that is 62.84 lakh, not contract value. Supreme Court by using Hudson formula uses the contract sum elementarily and wrong. Fifth, rough and ready justice. Division bench adjusted claims 12 and 13 using its own arithmetic and deducted claims number 2, 3 and 4, and which are separate and completely independent. A court under Supreme Court stated that the court under Section 34 can't do roughly and ready justice. The Supreme Court allowed the appeal and set aside the division bench order and restored the arbitral award in its full manner. The court reiterated that the on clause 10C, which talks about the statutory price rises, which is also the unrelated to higher charge or establishment claims. Clause 22, which was a general compensation, it was never raised before the arbitrator and given up before the division bench. How? On duplication. There is a prolonged contract which generates a multiple distinct heads material, cost, supervision, idle equipment, lost opportunity, and each one is legitimate. So there are 4 takeaways we carry forward from this judgment. The first, court under Section 34 are not appellate courts. They cannot re-examine the evidences of substitute their view of facts. Second, the arbitrator is the master of evidence. An award based on acceptable evidences cannot be disturbed merely because a court weighs it differently. Third, patent illegality, contrary to public policy, are the high threshold. Errors of interpretations or formula choice do not meet that bar. And fourth and lastly, judges must resist doing justice as they understand it, which belongs to the arbitrator. The court's role should be supervisory only, but not the appellate. That was the Associate Builders versus DDA and the clearest articulation of judicial review limits in the arbitration law. Thank you for watching this episode of podcast Bytes powered by India Law. I am Apnatva. Stay informed, stay precise, and let the law work for you. Jai Hind.